So my name is Lorena Oropesa, and I am the Associate Vice Chancellor for Academic Diversity within the Office of Academic Diversity. That office also is a home for GAMSA, the Center for Advancing Multicultural Perspectives on the Social Sciences, Arts, and Humanities. And I am just here to tell you that Professor Elvy is in the inaugural cohort of the GAMSA scholars. And what GAMSA seeks to do is build community and enhance retention among some of the most high demand scholars in the world, because, and especially in this country, because they're doing cutting edge research, which you look forward to hearing, but also really have a commitment to diversity, equity, inclusion that shines through their research, their service, and their teaching. So to be that kind of scholar who marries a commitment to equity with a commitment to cutting edge scholarship is just so important. And I'm really looking forward to Professor Elvy's talk. And what I'm going to do right now is to tell you more about that. I'm going to pass the baton to Professor Joe, also in the School of Law. So may I do that? Yes. And we need you to unmute. Yes, there we go. And I'll mute myself now. You can mute. There you go.
Thank you. Thank you so much. I really appreciate it. Hello, everybody. I'm very glad and very honored to get to be a part of this book talk by Professor Stacy-Ann Elvy. I'll spend a few minutes just introducing Professor Elvy to the group, and then she'll share with us a few words about her book and her research, and then we'll open it up for questions and answers. I believe that there are one of two ways for you to submit answers or questions, I think in the chat, and then also possibly we might be able to do it by raising of hands, but at the opportune time, we'll let people know what's the best method. So by way of introduction, a very brief and far too inadequate introduction to Professor Stacy-Ann Elvy. She is a professor of law and Martin Luther King Jr. Hall Research Scholar at the University of California, Davis School of Law. Her current research focuses on commercial law's relationship to emerging technology. Several of her articles have been identified and peer-reviewed by distinguished legal scholars as some of the best scholarship relating to commercial law and privacy law. Her scholarship has been published or is forthcoming in leading legal journals and books, including the Columbia Law Review, the Boston College Law Review, the Washington and Lee Law Review, and the Cambridge Handbook on Artificial Intelligence and the Law, printed by Cambridge University Press. And that's just to name a few. She has written several articles and presented at various conferences and roundtables evaluating the Internet of Things, including serving as an invited speaker at the Center for European Policy Studies Ideas Lab Conference in Belgium, and an exclusive Internet of Things roundtable held by the United States Departments of Justice and Homeland Security. Professor Elvy is an advisor to the American Law Institute's Principles for a Data Economy project. In 2019, she received both the Otto L. Walter Distinguished Writing Award and the UC Davis Kamsha Faculty Scholar Award. Professor Elvy has also previously served as the vice chair of the Article II Uniform Commercial Code Committee of the American Bar Association. So with just those few words to describe a really accomplished and distinguished career, I'll turn it over to Professor Elvy.
Thank you, Professor Joe, for that gracious introduction. So in prepping for the talk today, I had to decide between giving a high-level overview of the book versus doing a deep dive into one or two chapters from the book. So I thought I'd attempt to do a little bit of both to give you all a better sense of what the book is really about. So what I'll start by doing is giving a brief overview of some of the key themes from the book, and then I'll segue into briefly talking about three chapters from the book, chapters 1, 6, and 7. So as the title of the book suggests, right, the commercial law of privacy for the Internet of Things. So the book explores the consumer implications of the Internet of Things through the lens of commercial law and privacy and security law, with a primary focus on corporate conduct. And so the book's arguments can really be broken down into four main themes that are essentially woven through different chapters of the book. So first, I argue that the IoT, the Internet of Things, possible benefits. Despite these benefits, I argue that it potentially disrupts our privacy across a large range of contexts, raises significant data security concerns, and can further enable corporate digital domination. And I argue that several existing privacy and security law frameworks do not fully remedy these concerns. So second, I argue in the book that various commercial law frameworks can exacerbate and further enable the privacy, information security, and digital concerns that I think the IoT, the Internet of Things, raises. Commercial law provides, in some cases, various vehicles for the collection, transfer, and disclosure of our data as well, while in some cases allowing companies to shield themselves from liability. Third, I offer a two-pronged, comprehensive approach to address deficiencies in the covered sources of privacy and security in commercial law. Fourth, as the fourth theme of the book, is that the book offers several non-exhaustive reasons that in combination could explain the seeming disconnect between commercial law and privacy law and the consumer concerns of today's connected world. So in other words, I attempt to shed light on why I think these legal frameworks are inadequate. Now, all of these reasons that I offer in the book, I argue likely coalesce and perhaps contribute to a setting that allows many corporate actors to use commercial law frameworks to advance their interests, often at the expense of our privacy and security. So one explanation that I offer in the book is that despite the overlap of some concepts in both the commercial law and privacy law fields, privacy law and commercial law have historically focused primarily on addressing a distinct set of questions. So unlike privacy law discourse, which has predominantly explored questions and claims related to knowledge, access, and the use of information about us, commercial law, on the other hand, has long had a heavy focus on issues relating to trade, involving individuals, merchants, entities, right, corporations, et cetera. Commercial law, of course, is heavily focused on the transfer of rights in various types of assets. However, privacy and commercial law are increasingly overlapping, I argue, in the connected era. Now, this melding of the privacy law and commercial law worlds, right, it predates the IoT, but I think the IoT exacerbates the consumer concerns that arise from privacy laws and commercial laws in adequate recognition and resolution of these issues that are caused by the growing overlap. So another related reason that I offer in the book is that despite what appears to be distinct inquiries, both commercial law and privacy law historically reflect varying levels of deference to or respect for corporate practices. So this deference has likely contributed to an environment that allows corporate actors to use both bodies of law to best serve their interests. So in the privacy context, this deference has historically taken the form of a self-regulatory approach to privacy, right, and notice and choice. And as we all know, notice and choice has historically dominated the US approach, our approach to consumer data protection. So powerful tech companies have in some cases played a significant role in blocking proposed consumer privacy and security laws while advocating for more self-regulation and more of the notice and choice model. So the privacy notice and choice regime has to some extent also been duplicated in the commercial law arena as well. So the perfect example of this that I cover in the book are the amendments to the bankruptcy code that were adopted in 2005. Now, outside of privacy law's influence, commercial law has for some time on its own displayed a high regard for the development of commercial practices. So this respect for business customs appears to go beyond, I think, a mere recognition that commercial practices are going to evolve over time. Deference to commercial practices is actually evidenced by the text of the UCC, Uniform Commercial Code, which, as we know, that's an important source of commercial law in the US, right? So if you look at Article 1 of the UCC, for instance, it states that one of the core purposes of the code is to, quote, permit the continued expansion of commercial practices. And so given that one of the underlying purposes of the UCC is to facilitate the expansion of commercial practices, the development of modern day commercial practices involving data trade arrangements, and the potential applicability of the code to these types of transactions is perhaps in keeping with that goal. So this esteemed view of commercial practices combined with the role that corporate advocates play in the UCC revision processes, as well as the UCC's goal of uniformity, may explain why the UCC has not yet been revised to more adequately reflect consumer perspectives. So although there are currently several UCC provisions directly addressing consumers, the UCC has on the whole been somewhat unwelcoming to consumer protection issues and attempts to adapt various sources of commercial law to deal with technological developments have in notable cases either been unsuccessful or partially ineffective. So the 2005 amendment to the Bankruptcy Code and the failed Article 2B of the UCC project, which resulted in USITA, the Uniform Computer Information Transaction Act, are all examples of this issue that I talk about in the book. So today there's an ever-increasing blurring of the line separating the privacy and security law world and the commercial law world. And so the rise of the computer, modern databases, big data, companies' free and freemium data business models, and various other or newer forms of business models. And now the IoT have created an ever-increasing overlap between privacy and security law and commercial law. These business and technological developments have pushed us deeper into the realm of what I call the commercial law of privacy and security. And so the result today is that our concerns about privacy and security are intricately connected to the commercial law frameworks that allow companies to exploit our data. So in today's connected world, our concerns about who should know us and how others should know us are determined by the privacy law and commercial law frameworks that govern firms' data collection, monetization, transfer, and disclosure practices. So as I mentioned earlier, the book offers a two-pronged approach to better account for the increasing overlap between commercial law and privacy and security concerns in the Internet of Things age, right, the IoT age. So first, as we know, the lack of a comprehensive privacy statute at the federal level in the US, that's somewhat different from, or I suppose quite different from, the regulatory approaches or different regulatory approaches that have been adopted in other parts of the world. And so the book joins earlier recommendations by other scholars in support of relying on some aspects of the European data privacy and security approach in reformulating our approach, the US approach to privacy. I also argue that some provisions from US domestic frameworks can also be useful sources as well. So of course, I know in the book that the US and European legal landscape are distinct, right? So while select principles from the GDPR, the European General Data Protection Regulation, can be used to inspire a federal statute, right? In some cases, these provisions will have to be tailored or narrowed to better fit the US legal system. And so I use the term GDPR-like in chapter 8 in the book to reflect the fact that although some provisions in a federal statute can be somewhat similar to those that are found in the GDPR, right, they need not be wholly identical to GDPR provisions or principles. I also argue that federal legislation can shed light on permissible data practices and impose prohibitions on certain data-related activities. And so a comprehensive baseline privacy and information security federal statute that is more than just mandate, notice, and choice, and that establishes the contours of acceptable and unacceptable data practices, I think is a key step in safeguarding consumer interests. And as we know, the FTC, the Federal Trade Commission, some academics, some consumer advocates, and others have long recommended that Congress enact various versions of a comprehensive federal privacy and security statute. Federal legislation could, for instance, specifically require rather than merely recommend data minimization and privacy and security by design and default. However, any comprehensive federal legislation will need to contend effectively with the existing federal sectorial legislation that's currently in place and the role that states can play subsequently in protecting consumer privacy going forward. So as we know, in the last few years, some states have been really active in addressing privacy issues at the legislative level, right? So for example, here in California, right, we have the CCPA, which grants California consumers certain rights, some of which are somewhat similar to those that are contained in the GDPR. And the CCPA restricts companies' ability to force consumers to waive statutorily granted privacy rights by expressly providing that any such contractual provisions are potentially invalid. New developments such as global privacy controls, which were endorsed by the California AG in July of this year, may also allow consumers to exercise their opt-out rights under the CCPA globally on their browsers or devices, rather than having to exercise those rights individually via each website or via email or telephone. So as we know, state privacy law efforts to provide more stringent protections for consumers has to be drafted with existing federal legislation in mind, as well as constitutional limitations, right? And so for instance, if we look at COPA, that's the federal law that protects the online privacy of children, right? It preempts state law. And as a result, although preemption, as we know, it's an incredibly complex topic, states are likely limited in their ability to adopt legislation that's inconsistent with COPA's framework. But despite this restriction, there is still some room for state activism in the child data arena, right? So states can likely adopt legislation that's consistent with COPA's framework for COPA-covered children, and perhaps even adopt more privacy protective legislation for non-COPA children and in instances in which COPA's framework does not apply. So as I mentioned earlier, I argue that a comprehensive two-pronged approach can help to reconcile provisions in commercial law and privacy law frameworks that enable consumer harms. So in addition to joining earlier calls for the adoption of a baseline privacy and security statute at the federal level, I also propose revisions to important sources of law that govern commercial activity, such as the Uniform Commercial Code and the Bankruptcy Code. So the book is comprised really of three parts. In part one of the book, I evaluate the vast consumer privacy and security implications that I think the IoT raises. And part one presents an overview and critique of several leading privacy and security legal frameworks that are applicable in the IoT context. In part two of the book, I segue into focusing on commercial law. So part two of the book offers a critical survey of some commercial law frameworks that allow companies to transfer and disclose our data. And then in part two of the book, that's where I offer several solutions that I mentioned earlier. So that's the broad level overview of the core themes and parts of the book. So let me segue into providing more information about chapter one, and then I'll talk briefly about chapter 6 and chapter 7. So in chapter 1, I highlight 4 privacy concerns that I think the IoT raises. So first is the further corporate invasion or colonization of traditionally private and intimate spaces. Second is the potential reduction in our ability to be anonymous while conducting ordinary activities. Third is the potential for worsening unequal access to privacy and cybersecurity. And the last concern is the potential for IoT data to be used to impact our behaviors, to potentially discriminate against us, and to influence the opportunities that we receive. So in the IoT setting, companies can collect much more than just our names, our addresses, our browsing history, and financial information. And so the customer databases of today's world of today's companies, I should say, are already expanding to include health-related data and biometric-related data and other types of highly sensitive data about us, right? Other types of data that IoT devices can collect include location data, consumption rate data, environmental data, and by environmental data, I mean data that, for instance, concerns our surroundings or physical surroundings. So for instance, our home layout data, right? That could be described as environmental data as well. And I use the term health related data in the book to primarily refer to data that does not, that it's not generally viewed as medical records, right? And it's typically not subject to HIPAA, which is a federal law that deals with health-related information in connection with the provision of medical services, right? So essentially what we're seeing is that new types of data that were not previously accessible to organizations on a wide scale, or perhaps even seen in customer databases of some companies before, are now becoming more readily available. So I argue that the ubiquitous nature of the IoT, the Internet of Things, and the continuous streams of data that are generated together with companies' data business models and programs can allow companies to expand surveillance capitalism in the IoT context, right? And surveillance capitalism, right? That's a term that's coined by Professor Shoshana Zuboff to primarily refer to companies' commodification of consumer data. So turning now to the privacy concerns that I mentioned earlier. So first on the list is the further corporate colonization of the private sphere. So I argue that IoT devices and services are possibly Trojan horses, right? That allow companies to further invade what were once traditionally intimate spaces while purporting to provide us with necessary convenience. These intimate spaces include our homes and in some cases our bodies as well. IoT devices can record and observe almost everything that goes on in our homes, including our in-home conversations and the things that we watch on TV, right? Wearable IoT devices allow companies to obtain, in some cases, deep insights and real-time data about our physical, mental, and emotional well-being as well. And this corporate invasion also has, unfortunately, in some cases, unintended consequences for vulnerable groups, including domestic violence victims. So some women have reported their abusers using IoT devices such as internet connected doorbells, cameras, and ACs to remotely observe and harass them. So the second privacy concern that I cover in chapter 1 that I think the IoT raises is that it has the potential to reduce our ability to be anonymous. So once our bodies and homes are fully colonized by IoT devices, traditionally routine and offline activities are then potentially transformed into online activity. In other words, our online activities are no longer just limited to accessing the internet via our smartphones, our tablets, or our computers, right? And so instead, mundane everyday activities, such as perhaps drinking water from an internet-connected pitcher or doing laundry from an internet-enabled washing machine, could be then transformed into an online action. So there's this offline online conversion. So the transformation of offline activity to online activity enables surveillance, and it also increases the likelihood that our data from our new online activities, right, could be used to reveal our identities, as well as perhaps even our very nature. So these data could also potentially be combined with other disparate sources of data as well. So Internet of Things devices and the biometric data they generate, combined with advancements in facial recognition technology, can also potentially reduce our capacity to be anonymous in public. So malls, for instance, can use facial recognition and detection technology to monitor, identify, and categorize individuals by age, race, gender, and shopping habits. Internet of Things city infrastructure, so things like smart street lights and cameras that can record audio and images and track movements may also potentially be problematic, right? So over-policed communities are perhaps particularly vulnerable to the government's use of smart city infrastructure. So the third privacy concern I cover in chapter 1 deals with the issue of unequal access to privacy and cybersecurity. So once our bodies and our homes have been invaded by IoT devices and our ability to be anonymous decreases, the stage is then potentially set for companies to use their various data business models and offerings to further transform privacy and cybersecurity into premium products. So once privacy and cybersecurity are further transformed into premium products, right, then the gap between the quote haves and privacy haves and have-nots, right, potentially widens, right? IoT devices are historically been viewed as notoriously insecure, right? So in the IoT setting, one could easily imagine a scenario in which companies that offer devices with strong privacy and cybersecurity features charge higher prices than those that do not. In such an instance, more secure privacy and security centered products or oriented products, right, could be beyond the reach of low-income consumers. So everyday companies are building connectivity into more and more ordinary objects, right? And more objects are potentially being replaced by their IoT equivalent. So in the same way that CRT TVs were rendered obsolete, so CRT TVs, those were those massive 60-pound televisions that you needed about 3 or 4 people to lift them because they were so heavy, right? So in the same way that CRT televisions were rendered obsolete by flat screen TVs, for instance, eventually we may all have no choice but to purchase the IoT versions of the in-home products and objects that we currently own. So those of us that are able to pay for privacy and cybersecurity centered products, such as smartphones with strong encryption technologies and VPN services, are likely better off than those who cannot. So individuals that can afford to pay for privacy and cybersecurity likely obtain more data protection when compared to those who cannot afford to pay for those types of products. In other words, consumers who are knowledgeable about privacy and security related issues and who can pay for privacy and security are likely in a more advantageous position than those who cannot, and that they can afford to avail themselves of technological offerings to limit tracking, perhaps limit data collection while accessing the internet. Now, another complicating factor is that low income and minority consumers have historically had less options for online access. And so with the rise of the IoT, it could mean that even when these groups of consumers obtain access to the internet, they could be subject to more data collection unless they're able to pay for the products and services that companies offer to shield themselves from surveillance. So children are especially vulnerable to the dangers of unequal access to privacy and security as well, right? So some groups of parents are to some extent, arguably already commodifying their children's data, right, for monetary compensation. So the parents of children who can afford to purchase privacy and cybersecurity centered IoT products, and you have more knowledge about privacy related issues, may have more protection from pervasive surveillance. Some research indicates that higher income parents are more likely to evaluate the mobile applications downloaded by their children and are perhaps more knowledgeable about privacy concerns. Another study found that children from lower education households may be at increased risk for privacy violations, as these households had higher counts of data transmissions to a larger number of third parties. So the last privacy concern I discussed in chapter 1 is the potential for our data to be used by entities to shape our behaviors and opportunities and perhaps to discriminate against us. So several scholars have highlighted the discriminatory potential of big data. And as I noted in the chapter, the IoT has the potential to make big data even bigger and perhaps even more accurate. So once traditionally private spaces are fully colonized, we all end up leaving longer and more detailed digital footprints. So companies can then analyze and perhaps even monetize this data to influence our decisions and to determine the opportunities we receive. So as I mentioned earlier, I'm also concerned about the impact on children. And so the digital dossiers that can be compiled about children from a very young age could have negative long-term consequences once a child reaches adulthood. So companies could perhaps use child data to shape children's preferences and make accurate inferences about their future adulthood preferences and behaviors. So that's essentially chapter 1, which sets the stage for the rest of the chapters in part 1 of the book, which really focus on general privacy and security issues. So moving on now to chapter 6, which is included in part 2 of the book. In part 2 of the book, I explore commercial law's role in enabling some privacy and security concerns. So chapter 6 deals with the rise of asset collection technology in consumer financing transactions. And in the book, I use the term asset collection technology to describe the various devices and associated systems and services that businesses use in consumer lending transactions to protect their rights and to remotely control or retrieve collateral. So examples of this technology include starter interrupt devices, SIDs, for instance, and other GPS tracking devices that are installed in consumers' vehicles as a condition of financing. Data from automated license plate reader technology is also another potential example of this as well that I talk about in the book. So in chapter 6, I primarily turn a critical eye towards the subprime auto lending industry. And so lenders in the subprime auto lending market are increasingly requiring subprime borrowers to consent to the installation of asset collection technology in their vehicles in connection with loan approval. So the VP of one SID provider, starter interrupt device, the VP of one SID provider estimates that up to approximately 70% of subprime borrowers' vehicles are accompanied by asset collection devices. So I highlight 2 disturbing problems in chapter 6. So first, I argue that when we participate in lending marketplaces with asset collection technology and IoT devices, we are vulnerable to privacy intrusions, loss of device control, the imposition of digital restraints, and notable lifestyle and daily interruptions post-transaction. Second, consumer concerns that are associated with asset collection technology and IoT devices could be disproportionately borne by low-income and other historically marginalized groups. And that's despite the fact that there's existing legislation that prohibits discrimination in credit transactions. And this then also potentially exacerbates unequal access to privacy and security, which is an issue I highlighted in chapter 1. So financing transactions, including subprime vehicle lending arrangements between consumers and creditors, can be subject to various sources of state and federal law. But rather than focusing primarily on federal law, chapter 6 of my book focuses really I spend much of my time in chapter 6 focusing on Article 9 of the Uniform Commercial Code, which is an important source of law that impacts consumer lending transaction. So Article 9 generally governs transactions that create a security interest in personal property. And a security interest is basically just a lien on personal property. And there are different types of personal property that can be used in an Article 9 transaction, including goods, general intangibles, which covers things like IP, intellectual property rights, and also there's also chattel paper as well, another type of property. So if an individual, for instance, who's bought a vehicle has obtained a loan from a creditor to finance the transaction, and the creditor takes a security interest in the vehicle, so a lien, right, to secure the purchase price, the transaction is likely going to be subject to Article 9 of the UCC, as well as other sources of state and federal law. So as expected, the failure to make timely payments is likely to qualify as an event of default under the loan agreement. So if the consumer is in default, Article 9 provides a secured party, the lender or the creditor in whose favor the lien, the security interest is created, with various rights, including the right to take possession of the collateral, subject to some limitations. So once asset collection technology, such as a starter interrupt device, is installed in the vehicle, a creditor has the ability to remotely and easily disable the vehicle upon default. In addition to remote disablement, asset collection technology can also be used by a lender to send borrowers multiple payment reminders via a series of tones that's emitted by the device. And these tones can grow louder and more frequent as the date of payment nears. And that's also potentially in addition to phone calls, texts, and emails, reminders as well about payments. So asset collection devices can also be used by lenders to track the vehicles, and then by default, potentially the borrower's location as well. So some providers of asset collection technology, they argue that they protect borrowers' privacy and that they design their devices to only collect location data once the borrower is actually in default under the loan agreement. However, other companies that provide these types of devices, right? So other asset collection products that are advertised by other companies can provide and obtain, for instance, a vehicle's location on demand, right? Detailed location history reports can be generated that exposes where a vehicle was and where it's likely going to be in the future. Location data can also be collected when lenders are periodically testing the devices to ensure that borrowers are not tampering with the device, and also to ensure that the vehicle hasn't actually been permanently moved to another location without the lender's knowledge as well. And so the possibility of continuous or periodic location tracking, which could in theory occur before, both before and after default, could potentially be described, and it's been described by some as a privacy tax, right, that's paid by subprime vehicle borrowers. And so the asset collection devices, for instance, of one provider includes pinpoint GPS tracking, geofencing features, speed alerts, automated 49-hour tracking. Another company offers products that can be accompanied by daily device history, excessive mileage reports. Some of their products are also accompanied by starter interrupt features as well. So some asset collection technology providers also offer companion products dealers can market directly to consumers. So for instance, one company offers a mobile app that consumers can purchase from dealers and then bundle into their loans as an add-on to allow dealers to recoup their GPS costs. And so the companion mobile app provides consumers with various connected services that essentially are akin to those that you might find in newer model vehicles, and that effectively brings these older vehicles into the IoT. And some of the features include location tracking, geofencing, and speed alerts as well. And so for those consumers who choose to purchase companion mobile apps, it's not entirely clear which parties other than the consumer and the company will have access to the data that's been collected, and whether the data can be aggregated and anonymized and then subsequently monetized are used by lenders to better enforce their rights in lending transactions. And there are several studies that I cover in chapter 2 of the book that have found that anonymized and aggregated data can be de-anonymized. So with respect to vehicle loan add-ons, such as the companion mobile app I mentioned earlier, it's notable that a study by the Center for Responsible Lending on vehicle dealer practices determined that African-American and Hispanic borrowers were nearly twice as likely to be sold multiple add-on products when compared to Caucasian customers. And add-on products can potentially increase the loan balance, and they're potentially associated with higher rates of repossession and delinquencies. The study then went on to note that dealers may convince consumers that these add-on products are actually a condition of loan approval. And some prime borrowers are perhaps particularly vulnerable to these types of tactics because many of them are limited to indirect lending transactions, and they may not actually believe that they have alternative access to or have different access to other sources of financing. So the add-on products problem is also perhaps compounded by dealers' discretion in marking up interest rates for loans. So research also suggests that discretionary interest rate markups can also have a discriminatory impact on minority borrowers. So with indirect loans, the dealers facilitate indirect financing through a third-party lender, right? And the third-party lender essentially sets the interest rate and gives the dealer the discretion to mark up or increase the final interest rate that's given to the borrower. And then the dealer and the lender essentially they share the additional profits from the markup. And so dealerships can get a significant amount of funds from marking up interest rates, but of course the dealer has the discretion to determine which consumers' interest rates are marked up. So the CFPB, the Consumer Financial Protection Bureau, has previously pursued auto dealerships for discriminatory markups in violation of federal law, the Equal Credit Opportunity Act, which prohibits discrimination in credit transactions on the basis of certain types of protected characteristics. So for instance, race. Unfortunately, though, the CFPB's prior guidance on indirect dealer markups was dismantled by Congress, although the actual statute, the Equal Credit Act, the Opportunity Act that I mentioned earlier, and its associated regulations, right, are still in place. So today, there appears to be a regulatory gap with respect to clear and definitive rules to govern dealer markups on the issue. Right. And that's because the FTC has not yet issued rules to govern dealer markups within its jurisdiction. And that's even though the FTC was authorized to do so under the Dodd-Frank Act, which was adopted, I believe, more than 10 years ago. And in fact, it wasn't until last year that the FTC brought its first ECOA, Equal Credit Opportunity Act, action since the adoption of the Dodd-Frank Act against an automobile dealership for discretionary dealer markups. For discriminatory discretionary dealer markups, I should say. So asset collection technology may provide some benefits to both subprime borrowers and vehicle dealers and lenders. And this technology can in theory decrease repossession costs, allow borrowers to quickly cure defaults, and perhaps increase subprime borrowers' access to credit. But despite these possible benefits, I argue that there are potentially significant privacy concerns that are associated with the use of asset collection technology in light of the types of information that can possibly be collected from these devices, as well as the add-on products that can be sold to consumers by dealers. Lenders who have access to a subprime borrower's vehicle location through the use of asset collection technology, whether it's before or after default, could, for instance, potentially also determine if the subprime borrower is no longer going to their place of employment. So for instance, the New York Times investigation on asset collection technology devices revealed that the director of collections at one credit union could monitor the movements of approximately 900 subprime borrowers at any time, and then remotely disable the vehicles of select borrowers who were late in making payments on his smartphone while he was shopping in Walmart. So although consumer automobile lenders that provide financing have long retained some degree of control over consumers post-transaction, I think the examples I mentioned earlier suggest that asset collection technology may allow lenders to extend this post-transaction control over consumers and their vehicles, and potentially collect significant amounts of data about consumers' driving habits and their frequently visited locations. SID, starter interrupt device, and geofence features are examples of this growing post-transaction control. And although less problematic, the payment reminder features of these devices are also possibly concerning as well. So returning now to Article 9, which I mentioned earlier, recall that Article 9 gives lenders the ability to go after the collateral once a debtor is in default. So a lender that uses asset collection technology to locate and then physically acquire a vehicle through its repossession agent has exercised its right of repossession under Article 9. So if a lender uses data such as driving behavior reports or historical location data that's collected from an asset collection technology device that's installed in a consumer's vehicle to aid in physically repossessing the vehicle, then that's permissible under Article 9, right? However, an important legal issue that is perhaps in dispute is whether a lender's use of asset collection technology to simply remotely disable the vehicle rather than physically repossess it, whether it qualifies or should qualify as a repossession without a breach of the peace under state law. So Article 9 does not expressly forbid the use of electronic self-help or remote disablement in the consumer context, and that's unlike other sources of commercial law. And in the absence of clear restrictions on this issue, at least in connection with Article 9, right? In the absence of clear restrictions here in consumer transactions, the practice of remote disablement has grown. So under Article 9, a lender can disable equipment, which is a type of collateral under Article 9, right after default, but the lender has to do that without breaching the peace. And some commentators have suggested that using an SID to disable a vehicle is akin to the equipment disablement provisions in Article 9, right? And so SID usage should be then permissible under Article 9 via or by analogy. However, the term equipment is actually specifically defined in Article 9, right? And it's unlikely that a consumer's vehicle qualifies as equipment. It's more likely to qualify as consumer goods under Article 9. Now, Article 9, as I mentioned earlier, it also allows a lender to repossess the motor vehicle after the consumer defaults without first going to court. And so the creditor can exercise this remedy of self-help only if it does not breach the peace. And the term breach of the peace is not defined in the UCC. But if a lender's repossession is viewed as improper, the lender's ability to collect, for instance, a deficiency judgment in a consumer lending transaction could be restricted. Other sources of state law, such as the Uniform Consumer Credit Act, also imposes a breach of the peace limitation on repossessions as well. So if a repossession is defined as requiring the lender to actually have physical possession of the collateral, then disabling the vehicle using an SID would not qualify as a repossession and would arguably then not be subject to the breach of the peace standard under Article 9. And so it's not entirely clear whether a lender's use of asset collection technology after default will constitute a breach of the peace under Article 9 to the extent that the breach of the peace standard even applies. State law can also permit lenders to repossess collateral after a specified, or other sources of state law, I should say, can also permit a lender to repossess collateral after a specified number of days after a missed payment. And there have been reports of lenders disabling vehicles within a few days after a missed payment, and in some cases, even when the buyer is not technically in default under the loan agreement. Some states have specifically addressed the issue by adopting laws to deal with asset collection technology. And I cover some of the provisions in these laws in Chapter 6. And so, for instance, New Jersey allows SIDs to be used in consumer transactions and obligates creditors to provide notice. Nevada has the most notable statute on the issue. Nevada's asset collection technology statute expressly provides that the use of an SID to disable a motor vehicle constitutes a, quote, constructive repossession, which I think perhaps suggests that the breach of the peace standard would apply to remote disablement in Nevada. Nevada also notably imposes data disclosure and transfer restrictions on asset collection technology data as well. And at least 2 other states have adopted non-uniform amendments to Article 9 as well to deal with remote disablement. California also has its own restrictions on certain dealers' use of asset collection technology as well. So in short, state asset collection technology laws, they often permit the use of this technology and electronic self-help subject to some requirements and limitations. But some of these laws appear to also rely significantly on the notice and choice model to protect borrowers in transactions that involve asset collection technology. And legal scholars, as we know, have long highlighted the many failures of relying excessively on notice and choice in the privacy context. And so with potentially less alternatives, a subprime borrower may actually have no choice but to agree to a creditor's use of asset collecting technology to obtain access to a vehicle. And we all know that as consumers, right, that we have to review and execute a significant number of documents in lending transactions. And this is often times required by law. So there's a 2020 report by the FTC Bureau of Economics and the FTC Bureau of Consumer Protection that detailed the experiences of consumers who are buying vehicles. And the report found that many of the surveyed consumers reported being mentally fatigued by the time they were signing the lending paperwork, right? And many of them weren't really paying attention to specific contract items, such as the price of the car, add-ons, and mandatory fees. And then the report went on to acknowledge, though, that additional disclosures could further increase the duration of the transaction or potentially the already large amount of documents and paperwork that individuals have to review. So what can we do about companies' use of asset collection technology in financing transactions? So one alternative that I cover in Chapter 6 and also in Chapter 9 is for states to adopt non-uniform amendments to Article 9 to limit electronic self-help measures in the consumer goods context. So we could expressly indicate, for instance, that a lender's use of asset collection technology in the consumer goods context constitutes a repossession. I know this might require other amendments to Article 9, other amendments to other provisions in Article 9 that deal with repossessions. And we could also amend Article 9 to provide that the remote disablement is in fact subject to the breach of the peace standard. Another alternative is to attempt to limit companies' ability to condition loan approval on consumers consenting to the installation of these devices in their vehicles. So that's Chapter 6. And then moving on now briefly to Chapter 7, which provides examples of the ways in which commercial law can facilitate data transfers in corporate transactions by looking at the bankruptcy code and other sources of law. So companies' privacy policies often include provisions that authorize them or permit them to transfer consumer data in various transactions, including bankruptcy proceedings. So in Chapter 7, I argue essentially that existing commercial law frameworks, such as the bankruptcy code, including the 05 amendment to the bankruptcy code, they rely heavily on the notice and choice model and the provisions of a company's privacy policy to determine the level of protection that's given to consumers' data, right, that these legal frameworks do not effectively safeguard our interests. So in bankruptcy, many of a company's assets will typically become part of the debtor's estate, right, and customer databases and the intellectual property rights that are associated with these databases are assets that can be included in that estate. So for instance, when Pay by Touch, there was a biometric company, when they filed for bankruptcy a few years ago, the company's assets included in its customer database, right, the biometric templates of, I believe, over 2 million individuals. Third-party entities can also purchase and obtain access to consumer data in connection with purchasing a bankrupt company's assets. So for instance, when Philip, that was an IoT company, when they filed for bankruptcy, the company's assets included data about children and parents who use the company's products. The bankruptcy court approved the sale of the company's assets to a software firm. When Radio Shack initiated bankruptcy a few years ago as well, the company's assets, which included its database of 117 million customer records, right? Some of these records were purchased by Standard General. A bankrupt sports authority sold its customer base and assets to Dick's Sporting Goods for about 15 million. So under the 2005 amendments to the bankruptcy code, if the debtor's privacy policy in effect at the commencement of a bankruptcy action prohibits the transfer of consumer data to third parties, the transfer is permissible only if it's consistent with the debtor's existing privacy policy or upon the appointment of a CPO, so a consumer privacy ombudsman, and then a court approval of the transfer. So given the language in the code, right, the 2005 amendment to the bankruptcy code, a CPO is arguably not required to be appointed if the debtor did not actually provide notice to individuals of a privacy policy, or where the sale of the data is actually consistent with the debtor's privacy policy. And so the language in the debtor's privacy policy controls the level of scrutiny that will be given to the transfer or sale of consumer data in bankruptcy proceedings. So if the provisions of the privacy policy allow the sale of the data, it can potentially be sold without CPO involvement or oversight. So we know that both IoT companies and non-IoT companies, they're routinely including bankruptcy and asset sale carve-outs in their privacy policies. And so in light of this, I argue that the bankruptcy code places too much reliance on the language in the debtor's existing privacy policy at the time the bankruptcy proceeding commences. So one solution that I offer in the book to address bankruptcy proceedings is, or the transfer of data in bankruptcy proceedings, is to amend the bankruptcy code to require that courts appoint a CPO and consumer privacy ombudsman whenever consumer data are offered for sale in bankruptcy proceedings. So in other words, a CPO could potentially be appointed to provide guidance to the court on whether the transfer and disclosure of the data should be approved. And that's even if the company in bankruptcy did not provide a privacy policy, or the company's existing privacy policy contains language that authorizes the transfer and disclosure of the data. And even if the consumer has consented to the privacy policy or the terms and conditions that actually contain the asset carve out. So to conclude, the volume and types of data about us that are now more easily available to companies has increased significantly. So what does the IoT's proliferation then mean for us as individuals, for us as consumers? So the book seeks to answer this question by highlighting the different ways in which commercial law impacts the pressing privacy and security issues of today's connected era. And as I mentioned earlier, the book offers a two-pronged comprehensive approach to usher in a more robust commercial law of privacy and security that I hope will better protect all of our interests, particularly our interests as individuals and as consumers. So I'll stop there and I look forward to questions. Thank you.
Thank you so much, Professor Elvy, for this book and for, it's really just an important and really meaningful contribution, I think, to the way that we all should think about, the things or Internet of Things and privacy. And so I really, really applaud you for writing this and thank you for this contribution.